Granting for the state.
Good afternoon, Your Honor. Theodore Edgecomb appearing in person with attorney Nick Ahmad and D'Avrio Lamar.
Afternoon. It's here for a sentencing after a jury trial. There have been a number of documents filed just in the last week to 10 days. The pre-sentence investigation was filed by the state. I have a number of letters on behalf of the defendant, about 25 pages worth, and I have another 25 or 30 pages worth of letters on or related to a victim impact statement and the victim in this case. I'm presuming both sides are ready to proceed. Is that correct?
Yes.
That is correct, Your Honor. Just for the record, there were some significant differences throughout the trial, but we have set those aside for the purposes of sentencing today. We are ready to proceed.
Fine, great. I'll hear from the state first, please. Can you tell me who, if anyone, wants to address the court?
Yes, Your Honor. We do have two individuals that would like to address the court. I would note that as the court can see, the victim's family is present. They have been notified. So I would ask that the court find that the state has complied with victim rights legislation at this time.
Fine, granted.
Thank you. Additionally, Your Honor, I would note that the state did provide to the court as well as to defense counsel a restitution request, as long with the paperwork regarding that restitution request. I guess I would like to know, I don't know if defense counsel knows if we need to set a restitution agreement or restitution hearing, or if that's going to be agreed to.
It was just filed today. It seems pretty basic. It's funeral expenses, but counsel?
Judge, it appears to be a reasonable request. I don't really see a basis to oppose it. I just wanted to show Mr. Edgecomb. Okay, we have no objection to that.
Fine. It's a rather straightforward request. It's funeral expenses, which are clearly compensable pursuant to statute in a case like this. So based on the stipulation, I'll order restitution in the amount of $4,840. It's payable to Mr. Cleereman's wife. State can proceed.
Thank you, Your Honor. I would also note, at least at this time, Your Honor, I have reviewed the pre-sentence investigation, and there's just one addition that I think should be addressed regarding the PSI, if the court would like me to address that at this point.
Sure.
I don't know necessarily how much the court is going to place on what I'm about to say, but considering the fact that the PSI spends a significant period of time in page 7 through 9, referring to the defendant's prior cases, some of which resulted in convictions, some of which did not, as well as I also, having read the defense counsel's sentencing motion, and there being significant talk about that, there is one case, everything in there is accurate in terms of what was issued, what was not issued. There is one case, however, or at least one interaction the defendant had with the judicial system that is not in there. It is case 17 CM 381. It was dismissed. It was a domestic violence battery case. It is the same victim, Ruby Mizell, that's RUBIE-MIZELL, that was the alleged victim in the 2019 case that is discussed on page 7 of the PSI. From what I've been able to see, that case was dismissed according to our files. That case is not in CCAP, so as all dismissed cases are. At a jury trial date, the state had requested an adjournment in order to see if they could obtain its witness. That adjournment was denied, and the case was dismissed by the court on that date. So that's just for what it's worth, since every other case has been dealt with, including tickets, I did think it was appropriate for us also to have a full, complete history of that history. Now, with that being said, Your Honor, there are two individuals that would like to speak on behalf of the victim's family. The first would be the victim's widow, Mrs. Cleereman.
Fine. Ma'am, when you're ready, if you can state your name and spell your first and last name, please.
My name is Evangelina Cleereman, spelled Evangelina. Cleereman, Cleereman.
Go ahead, take your time.
And Your Honor, just one moment. There are a number of photos that the family would like the court to take a look at, if you would not mind.
It's fine. Can you show them to the defense
I will
first,
do
please?
so.
Honorable Judge Borowski, my future did not include writing a victim impact statement. To explain the depth of my mental and physical pain due to the callous murder of my beloved husband, Jason Cleereman. My life and our children's lives were forever destroyed and altered on September 22nd, 2020. I was a witness to the cold-blooded murder of my husband. As physically close as I was to Jason when he was shot, I never had the opportunity to say goodbye, to hold him as he took his last breath, to kiss him, or to tell him that I love him, because he was already dead. He was already dead when the defendant pulled the trigger and made the conscious decision to put the bullet in my husband Jason's head. I believe the defendant's actions was intentional. You don't shoot someone and pretend you didn't know it would kill him. The physical and mental pain I suffer, and I will continue to suffer, seeing my husband killed is my new reality. It will be part of my past and future memories. It is part of my daily life. I didn't get a phone call to tell me that my husband was killed. I saw it myself. I will forever have the images in my head. They will be engraved in my memory, and they will be replayed in my head over and over for the rest of my life. I was a witness in the trial and a victim to the heinous crime that turned my world upside down. And then I was victim blamed during the trial, and because it was shared by the media, people questioned my actions. It crushed my soul being accused of not loving Jason, my beloved husband. I feel no need to justify my actions. I love my husband, and he knows I love him. Attempting CPR was not going to bring him back to me. Jason was dead before he hit the ground. I was there and I saw him die with my own eyes. A vision I wish I could erase, and a moment in time I wish could be reversed. I do not need to Your Honor, my husband was a wonderful man, loving husband, loving father, devoted. He worked hard for his family. He worked hard for his community. He was kind and caring and compassionate. I will continue to suffer the rest of my life. I would not wish for anyone to bear this pain. My heart will never be whole again. I will never feel complete. I will never fully heal from this tragedy. Our future of growing old together has been destroyed. I will never be able to happily celebrate family events because I will always carry deep sadness, emptiness, and pain, knowing Jason should be with our family, enjoying the life he loved and deserved. My husband does not get a second chance. Our family does not get a second chance. Can I take a break, please?
Sure.
I don't believe the defendant deserves a second chance. He's a cold-blooded murderer that took a husband, a father, a brother, a son, an uncle and nephew, a friend from a world that was much better with Jason in it. I believe the defendant has a responsibility to face this violent act, senseless act that took my husband, our father, our children's father, Jason T. Cleereman's life on Tuesday, September 22nd, 2020. What he did not only robbed us of Jason, but makes him a very dangerous person to society. I ask that you sentence this man to the maximum amount of time allowed. It will not change the events of that evening or change the future, but it will give me peace that myself or my children will not be harmed. I will have peace knowing that someone else's loved one will not cross paths with such an individual who's willing to lie to justify his violence. To my husband, I love you and I miss you with every part of my being. You have been a loving husband and father. Your life will be celebrated by your family and friends forever, but we all feel your void. Your legacy, your humor, and your ability to make people feel welcome will live on in all of our hearts. Thank you for being my partner, my other half, my husband, my true love. I am so grateful for the time we had together, and my heart will always ache for you. I miss holding your hand, sitting on the porch in the rain, sitting at the farmer's market while the vendors set up their booths, and you smiling and greeting everyone as everyone congregated in our neighborhood in unity. I miss your touch, your smile, your intelligence, and your worldly compassion. I miss your global ideas and vision. You are a man that did what you said you would do and said what you did. You're an amazing man, and I'm sorry for the people that would have crossed your path in the future because they will miss knowing a special person that will have made some difference in their life. Your family holds you in their hearts because you are part of us and always will be. We love you. Respectfully.
Thank you, ma'am.
Your Honor, there is a letter that Ms. Cleereman will read on behalf of her daughter.
It's fine. Just take your time, ma'am.
Dear Honorable Judge Borowski, I struggled to write this letter. The emotions and memories of my father are so very personal. I wanted to keep my feelings to myself. I can't fit everything into a short letter, and it feels wrong not to put down every single moment and memory. So to keep this short, I won't list off everything about my dad that I remember. And I know everyone else who wrote a letter has shared what made him such an asset to his community and to the world as a whole. What I will say is all the ways my life is over for not having him with me anymore. When my friends call their dads or buy something as a surprise, I feel angry. I won't ever be able to share something with him again. When I go on trips, I see plants and I go to take a photo and I stop and realize that it doesn't matter. I can't come home and excitedly show him the photo and ask him what kind of plant it is. I can't introduce guys to him anymore. He won't be able to walk me down the aisle. When I hear people complain about their dads, I want to scream and throw things and shake them because they still get to tell him that they're sorry. He'll still be there to hug them and tell them everything's okay. When they see something that reminds them of their dad, they can go home and tell him about it. Every new movie, every song that I hear, I think he might like, I'm reminded all over again that he's not here with me. And I'll never be able to hear his opinion. He won't sit next to me on the couch and tell me word for word, scene by scene, what's going to happen next. Who's going to ruin movies for me? Who's going to pull my toes until they crack while I scream and laugh? Or tell me that it doesn't matter because he wasn't the one when I get my heart broken. I'm never going to get to ask him a question again. He knew everything. I didn't even need Google. Even the stories everyone shares in his memory hurt. I'll hear one I never knew, and I want to turn and ask him, is that true? And then I remember. When someone tells a story and I remember one he told me that was similar, and I can't remember a specific part or the exact words that he used, I grab my phone to call him. And I remember that his phone is at home in a drawer with his wallet. He was so proud of us, of my mother and my brother and I. He thought all my artwork was exceptional. One year for Father's Day, I framed a painting I made in elementary school and gave it to him. And he posted it on Facebook and called it the best gift he's ever gotten. Mourning my dad is even harder for me because of the way he died and how public it became. Judgment from strangers, input from people with no knowledge of the person he was, and really no idea of what happened besides what went viral. It's like losing him all over again every time I see or hear something about the trial. I can't stop thinking about hearing him get up in the middle of the night and how I thought to myself, yell out, I love you. And I didn't, because I thought I had tomorrow. Respectfully, Amelia.
Thank you.
And lastly will be Vanessa Maldonado, the sister of the victim.
Fine.
Thank you.
Ma'am, if you can state your name, spell your first and last name for the record, please.
Vanessa Maldonado, Vanessamalmadonado.
Go ahead.
Jason Cleereman is my friend, my confidant, my mentor, my compass, my hero, and above all,
Hang on.
sorry.
If you're reading, my reporter has to take this down, so just take your time. There's no rush.
Okay. Jason Cleereman is my friend, my confidant, my mentor, my compass, my hero, and above all, my big brother. It's incredibly difficult to express the impact his sudden violent death has had on me when it seems like it's limited to writing it on a grain of sand. The loss of my brother Jason has undeniably left an emptiness deep in my heart and soul. A place now filled with mostly cherished memories, an empty hole for future memories never to be had, and a dark hole filled with hate and anger. My sorrow is not limited to my own loss. There is a trickle-down effect of emotions, a pain that blankets my brother's family since that night. There is no loss greater than theirs. My sister-in-law was a mere 20 to 30 feet from her husband when he instantly dropped face first on the concrete after being shot with a gun in the forehead. This is her last memory before seeing him lying in a casket 8 days later. The last images so horrifically traumatic, they had temporarily erased all the great memories she had with Jason. Jason's family has lost the most. Their new reality is that their future family events and milestones will no longer include him. Movie nights, bonfires, holidays, birthdays, college graduations, weddings, grandchildren. There are numerous instances when Evangelina has just crumbled because she can no longer hold her aching loneliness and emptiness for the loss of her husband. I have seen her smile and immediately stop because she feels she has no right to be happy without her husband to enjoy it too. I see my niece make attempts to choke back her tears because it's so overwhelmingly hard for her to release her emotions. And then there are instances where out of the blue she will cry. You know that her thoughts are of her father and memories that she wants to hold in her heart silently because it's too much for her to share with the outside world. It's too intimate for her to believe anyone could understand her pain. I see my nephew who remains emotionally silent in the presence of others, strong and serious, and a sadness in his eyes. At 20 years old, he feels his role is to take care of his mother and sister. He should not have to carry such a burden. I can't escape the words my nephew said to me when I hugged him on the street that dreadful night. He said, "At an age when you need your father the most." Those words alone say enough about his pain. My brother was murdered on a Tuesday, September 22nd, 2020. It was not a weekend, as T. Edgecomb stated when asked why he had a firearm on September 22nd. He was not carrying a gun for protection because there were a lot of people out and crime was on the rise. He personally contributed to the increase in crime. If the weekend was when he carried his gun, then my brother would still be alive. It was a Tuesday when my brother was taken from this world. My brother was a man of action, an educator, a leader, an activist, an advocate, an environmentalist, a man of compassion and empathy. He was a voice for those unheard. He made a difference in everything he did. He believed that small things would reap great reward. He had a vision, small or large, and his vision included everyone. My brother did so much in his 54 years, and the things he did will benefit everyone, even in his death. I am proud of him, I love him, and I miss him very much. And I respectfully request that you sentence T. Edgecomb to the maximum time allowed so that he can take responsibility for murdering my brother, Jason Cleereman. Thank you.
Thank you, ma'am.
Your Honor, there is no one else from the victim's family that would like to address, so I will begin with my arguments. Your Honor, as the court is well aware, when fashioning a sentence, the court needs to determine and take into consideration a number of different factors. The character of the defendant, the serious nature of the crime, the need to protect the public, the need to send a message to the public and to the defendant that this conduct will not be tolerated, the need to rehabilitate the defendant, and the need to punish the defendant. The court heard this trial. The court saw the video in this case probably more times than you've ever seen a video ever before. So I'm not going to belabor too much the facts. I know the court is very well of the facts, and I'm just going to highlight a few of the portions that I think are the most important when the court needs to take into consideration the sentence here. I do think a good place for us to start is the character of the defendant, because there are aggravating and mitigating factors that the court needs to consider when attempting to determine the defendant's character and how it leads to what an appropriate sentence is. The PSI and the defendant's sentencing memorandum do highlight the fact that prior to this incident, the defendant only had one criminal conviction. That's true. He then pled guilty to misdemeanor bail jumping and felony bail jumping, and I'll get to those in a minute. The extent of the defendant's convictions up until this incident consisted entirely of one carrying a concealed weapon. The defendant did have a number of arrests, and we've talked about some of those beginning in 2008, and I'm not necessarily asking the court to take too much into consideration on that. I would note, though, Your Honor, that I do think one of the disorderly conduct is important for us to consider. That occurs on December 24th of 2016. The defendant is convicted of carrying a concealed weapon. Some of this is detailed on page 8 of the pre-sentence investigation. What happens on this case is the defendant goes into a store, a convenience store. He is witnessed by the owner of the convenience store concealing an amount of motor oil. When the owner of the store went to confront the defendant, a verbal confrontation ensued. According to the criminal complaint, as well as I believe portion of the PSI, this confrontation escalated. The defendant pushed the owner of the store and then reached into the right side of his waistband and produced a firearm. This caused the victim, according to what he told the police, to fear for his safety, and his words were his knees started to shake. He and the other employee present then went behind the register, which is surrounded by safety glass, locked the doors, and the defendant was trapped inside the store. Police officers arrived. The defendant was taken into custody without incident, and a black Ruger semi-automatic weapon officers could see was sticking out of the waistband of the defendant, and they recovered it. The defendant was originally charged with disorderly conduct while armed and CCW, carrying a concealed weapon. The defendant was convicted only of the disorderly conduct. The defendant was sentenced on the carrying a concealed weapon on, if I'm not, and I want to make sure I don't have any part of this wrong, in 2017. And in 2017, the defendant was sentenced on November 20th of 2017 to 30 days imposed and stayed, was placed on probation for a period of 6 months, and was provided with 25 hours of community service as well as no contact. that was the sentence that the court decided was inappropriate. Now, I would note that the PSI also does give us an amount or some insight into how the defendant reacted and how he dealt with probation. When he first appears, at his initial appearance, he tested positive for marijuana. He was informed that he would be referred for treatment. And then there is this incident involving a burglary, and I'll get to that in a minute. He was cooperative and everything was fine in regards to the arrest. There was a home visit, but unfortunately, then in February of 2018, and at his next appointment, he again tested positive. They discussed options, and then the defendant tested positive again 7 days later, and then didn't appear for his next 2 appointments. Approximately 2 months after that, he reports again for his next 2 appointments, and then 2 days later is discharged. He was discharged even though within the 90 days prior to that discharge, he missed 2 of his appointments and tested positive twice. That was the decision of the Department of Corrections. I would also note, Your Honor, that while that case was pending, the defendant was arrested and charged with disorderly conduct. It eventually was, as the PSI indicates on page 8, amended down to a disorderly conduct ticket. It is a result of what the defendant did while in a Milwaukee County courthouse, on which he became agitated while waiting for his case to became impatient, began using comments and obscenities in the courtroom, and eventually was taken into custody and used profane language and failed to cooperate with directives at the jail. It was amended to a forfeiture, and he received a fine as a result of that, and I believe is handled appropriately. But I do believe at least what we can see in regards to the defendant is that while he does have only 1 misdemeanor conviction, there is a consistent pattern of the defendant when it is not going the way he wants, escalating. When he is confronted about potentially there being a belief that he is stealing from his store, he pulls a gun. When there is being a confrontation about being abusive, he uses deadweight tactics and fails to cooperate. And just so we're clear, I understand that many people get upset. I get upset all the time. We've talked about that. So I don't necessarily know that in and of itself is that big of a deal. The CCW I find to be much more concerning because it does involve, as we see in this incident, the defendant going and pulling a firearm in what is either a verbal or possibly a physical confrontation. Now, in this case, the defendant did have 2 open cases. Those are dealt with in regards to the PSI. One is a felony. It was, if I'm not mistaken, a substantial battery and 2 counts of disorderly conduct. That was dismissed. It was dismissed because the victim in that case, Ruby Mizell, did not show and did not come to court. She is the same individual that the defendant was staying with when this incident occurred. There was a no contact order actually in effect when this occurred. So when the defendant gets his firearm from Ruby, which is what he testified to, there was no contact order in place. Ms. Mizell, and I want to make certain that the court understands this, he was never convicted of that because she did not cooperate. In fact, she wrote 2 letters to our office, which were presented to the court, I believe, in which she denied that the defendant did anything to her. She stated she harmed herself and the defendant was just trying to protect her. I would note that according to the criminal complaint, she stated that she was hit both at home, which is the same residence that the search warrant was done in this case, as well as in a car. Security video did show her fleeing a car with blood on her face, which officers saw, as well as a conversation in which there is an allegation that he broke a window at the house, as the PSI indicates. And when I read the criminal complaint, it was that the defendant was at her house yelling and attempting to get in, and that his voice was identified by his own daughter. The state was unable to proceed, but I would just simply note that we were unable to proceed due to Ms. L stating that it didn't happen, although the facts that the police have seem to put that in a little different light. Regardless of it, there's two things we know. The defendant was told to do two things: don't have a gun and don't have any contact with Ms. Mizell. And he did exactly those two things on this day. He also had pending in Waukesha another case that was 20 CM 458. And in that case, the defendant, as it's indicated, was pulled over. He is charged with, as a result, and that happened with, I believe there was an accident, or I should say it's not an accident, it's a crash that occurred in this case that is reflected and talked about in page 7 of the PSI. He had rear-ended another vehicle, was found to be intoxicated, and a loaded 9mm Ruger handgun was found inside the vehicle. He has been found guilty already of the ticket, a refusal to take an intoxilizer after arrest, and there is still pending the causing injury, operating while under the influence first offense with a BAC of over .15, the carrying a concealed weapon for which he had the 9mm handgun, a disorderly conduct, a resisting or obstructing an officer, an operating a firearm while intoxicated, and then the cause injury with a prohibited PAC, or prohibited alcohol level. That case is currently set for a plea and sentencing on May 13th of this year in Waukesha County. Again, what I would point out is the defendant was released on bail. He was just like he was released on a cash bail and was told not to possess any dangerous firearms or weapons. And then that leads us to this case. So when we look at the defendant's history, under no circumstances is it the most serious, or even comes close to the most serious history that this court or I or defense counsel have seen. It's very minimal. But it has portions that are alarming. One of his open cases is for violence, and he's told not to have a weapon. Another one of his open cases involves a firearm, and he's told not to have a weapon. His sole conviction involves illegally possessing a firearm that, according to the allegations, he brandished during an argument and pushed an individual. And then we're here for today, where the defendant is on his bike armed with a weapon that he is not supposed to have as a result of 2 court orders. The defendant has a disagreement with the Cleeremans. I do not believe that the defendant's testimony regarding flipping up on a car and all of that was at all credible. I did not find it to be credible. I will leave the court to take its own conclusions as to that. What the defendant did do, and what Ms. Cleereman had stated, is that he came out, which appears consistent with both what we saw in the video of where he was walking as well as what was about to happen, which was he was going into the street coming from the sidewalk. They swerve, some words are mentioned. We know that the defendant, instead of going where he said he was going, which was, I don't know, get some food or something, goes, and as he stated, he could not allow the Cleeremans to get away. He follows up, he pulls up alongside that vehicle, he asks if they were talking to him, he then punches Mr. Cleereman, and then, yes, he does go on. The Cleeremans do make that corner, and the victim does get out of the vehicle and does approach it. I do not agree with defense counsel's characterization. I believe he says that he refers to it as charging. I don't believe that that is the way that I viewed the video. I think that in this case, it is clear, as one of the witnesses stated, that he was following him. One witness stated he was possibly going to confront him. Another witness said he thought that he was getting ready in a boxer stance. He'd just been punched in the face. He was bleeding. The defendant pulled a firearm that he was not supposed to have. And just like he did in his CCW case, he decided to brandish the firearm. Again, illegally possessing it. He points that gun and he shoots the victim. There are aggravating and mitigating factors. He did only shoot once, but he did shoot the victim in the head, and the victim collapses. And then what the defendant does after that, I believe, is an aggravating factor. The defendant flees the state. He admits to ditching the gun. He takes steps to not get caught. He changes his hair. He lies to the police in Kentucky. He acts as though he has no idea what's going on with the Milwaukee Police Department. The police were looking for him in many states, including his family in Florida. When he's arrested, he calls a family member and says, "You know what to do," and one of his family members comes to the rental car that had been rented by Ruby Mazzell, we should not have had contact with because a no-contact order is still in effect, who he admitted on the stand that he, I think, went and hung out with. So again, that's another violation. And then a family member come and take some things out of the car. We don't know what those were. Maybe it was just clothes. I don't know. They said it was stuff for the child. It did not appear to be. But what we know is that the defendant was doing what he could to avoid being held responsible for what he did that day. From the moment he pulled the trigger until the moment the jury found him guilty, he was doing what he could to avoid being held responsible. And I believe that is an aggravating factor. Now, I understand that the victim's family is requesting the maximum penalty in this case. I am not. I do not believe that this is a maximum penalty case. I have explained this to the victim's family. I do believe that there are mitigating factors, a number of which we must consider. The victim did approach the defendant. The defendant did. He did shoot once. The defendant does not have anywhere near the significant record that we see in many of our cases, and maximum penalties should be reserved for those defendants, the worst defendant in terms of record, committing that crime in the worst way. And I don't believe that describes this defendant. But there are significant aggravating factors that do require a prison sentence in this case. The defendant has been placed on probation. That didn't work. The defendant was given court orders. That didn't work. And in regards to the burglary, Your Honor, that was no process by my office. I looked, there were questions to believe that it could be proved beyond a reasonable doubt, and even if it had been able to be proved beyond a reasonable doubt, it would have been something that would have gone to a DPA anyway, so it was not a case, it was no process. I don't think the court should factor it in any way in its decision-making. I know it's referenced, and I'll just let you know about that. This case for a long time did not have as much publicity. It did originally when it first occurred, but during the pendency of the case, there wasn't the amount of, well, let's say vitriol that was being seen towards the end. There was a lot of individuals that attempt to make this case something that it is not. This case should be viewed simply as to this defendant and what he did that day and nothing else. And that is the way the jury convicted. The defendant started a fist fight And when an individual came who he had punched in the face, he pulls a gun and he shot him once. And that is the way that this court should appropriately sentence this defendant. That and those are the only factors in the prism in which we should view this case, and nothing else. Everything else is people attempting to use this case for their own means, and that is unfair to the defendant, that is unfair to the victim, and that leads it leads to further division and derision. The one thing we should keep in mind, though, is that this is a case of, can we just admit that guns are not the answer to problems? This court knows better than anyone else. But in the last 2 years, since this homicide rate has gotten out of control, I mean, to proportions that the state has literally never seen in its entire history. Milwaukee has never had this many homicides. We set a record in 2020. We broke the record in 2021. And unlike what we saw in the 80s or even 10 years ago when we had the brief spike, which was when heroin was going out of control, this wasn't as a result of gangs or massive drugs. It's fights. It's literally people engaged in arguments and pulling guns and ending them with a bullet. This case is like so many the court has seen. The defendant stated on the stand that he took a gun because he needed to protect himself, but the only person that had a firearm in this encounter, the only person that used a firearm in this encounter, the only person that had a firearm in either one of the two cases that result from disagreements that the defendant was involved in and result in his convictions, his CCW in this, has been him both times. So with all of those factors, we need to consider what is the appropriate sentence. Your Honor, I do believe that the defendant should be sentenced to Wisconsin State Prison. I do believe that an appropriate amount of initial confinement in this case would be 25 years of initial confinement. I do believe that an appropriate amount of extended supervision would be 13 years of extended supervision. That would be a total sentence of 38 years. I do believe that that is where takes into account the aggravating and the mitigating factors that I have talked about. I think it is an appropriate sentence. How the court wants to set that up, whether or not it does it all on the homicide and then does the sentences on the bail jumpings concurrent, or if you split them up, I'll leave that to the wisdom of the court. I think when we consider what happened that night, as well as the character of the defendant, my recommendation is appropriate, and I'd ask that you follow it. Thank you.
Thank you. Defense?
Thank you, Your Honor. Before we begin, we did have 4 individuals who wanted to make brief statements on behalf of Mr. Edgecomb.
Fine.
The first person that would like to speak is James Bray.
Hello.
All right. State your name, spell your first and last name for the record, please.
My name is James Bry. James, J-A-M-A-S, and Bry, B-R-E-Y.
Go ahead.
I'm a retiree from Wisconsin Electric Forestry Department, and I'm currently a volunteer at Beckham Stapleton Little League. This is where I met Theodore, and I've got to know him through his volunteerism with the children as a T-ball coach. The image I have of Theodore is very different than what has previously been presented. I've known him as a compassionate father, a leader for the children. The image that I have on my phone is really from a picture taken at the Little League night in Miller Park. And Theodore has a baby strapped on his chest and holding his daughter in his hand and leading his team for the on-field parade. And children from other teams are coming around and looking at this sight in awe because he has really presented himself as a father figure and as a community person. And this is the image and the knowledge of Theodore that I have. And I just would like to share that with you. Thank you.
Fine. Counsel.
Next, we have Julie Abrahamian, who is his great-grandmother.
Ma'am, if you can state your name, spell your first and last name, please.
Yes, Your Honor. My name is Julie, Julie, Abrahamian, Abrahamian.
Go ahead.
Okay, I just wanted to talk about Malcolm. We call him Malcolm. That's his middle name. I wanted to talk about him and his grandfather, who I was married to, that how they're close like father and son. And I know Malcolm. I've been knowing him since he was 13. And the person that everybody's talking about, the way he is not the person I know. I know him to be a great father, and he is a great father. He has babies from age 1 to 8, which I see 3 of them almost on a daily basis that I watch the children. And the 6-year-old, the little boy, he's in therapy behind this right now. And he is always asking us to get his daddy out on bond. And he's acting out a little bit because it's affecting him. And he cries for his daddy every night. And then the 8-year-old is the little daughter that he went to get the food for that night down on Brady Street. And she's saying, if I would have never asked my father to get the food, this wouldn't have happened to him. And she's blaming herself. So it's pretty traumatic for the kids. And that's the most proudest thing that I wanted to say about Theodore is he's a great father. That's the most proudest thing. You're a great father. And I love you. And the thug mentality, everything that they're talking about with the thug is not what I see. I see a different person. I see a loyal person. When his grandfather passed away last January, he had flowers sent to me. He was going on trial for his life, you know. He was fighting for his life, and he had flowers sent to me for the passing of his grandfather. And I just thought that was so selfless of him, because that's the person I know. The other thing is he's loyal. He shows up for everything. If we call him to move, if everything we ask him to do, he comes. He's very loyal. He's the most loyal person in the family. He comes to all the vacations with us. I see him on a weekly basis. I love him, and this is just not the person I know. And when I did see the video that night, I thought he was coming home. I thought he was coming home. You know, he's not a perfect person. But what I saw is that he was trying to leave that scene. He was trying to go. He's not a killer. He's not a killer at all. I wouldn't be here if he was a killer. And if he would have been wanted to kill him, I'm sure it would have happened before that. He's not a killer. He was in fear for his life, and he told me that, and that's what I believe. I believe him. He was on that corner of that bridge, and I don't know what would have happened if I would have been on that corner of that bridge either. So I just wanted to tell you there's some great things about him. Is he perfect? No, I'm not perfect either, but I just wanted to say those things about him. He's a family man.
Thank you.
Third, we have Sonia Gordon, his mother.
Fine.
Hello.
You can spell your name first and last, please.
Sonya, last name is Gordon.
All right, go ahead, please.
Your Honor, I know you deal with a lot of cases, and a lot of cases end up with individuals being menaces to society. I guarantee you, and everyone here, that my son is not that at all. I'm not going to sugarcoat this information about my son, but give true facts because it should be known and noted. I'm asking for the minimum sentence for my son. He's a human being with rights. No, my son was not a doctor, a lawyer, or Indian chief, but he could have been. I say that because, yes, society has a way of playing various roles in our lives. My son dealt with society, but educated himself at the same time. Educated himself on being a black man, learning about his strong heritage, as well as education just in general. My son had what I thought was behavioral issues in grade school, which turned out he was not being challenged enough. In third grade, he had to attend the fourth grade reading and math classes, which showed how smart and intelligent he was and what they saw in him. He graduated from high school and went away to college in Florida, studying criminal justice like his mom and dad. We would play family word games at home, and every time it was his turn to put a word, to come up with a word, it ended up being a word my family and I would challenge because we were unfamiliar with the words. The words used would be in the dictionary, no doubt. Later on, I found out a secret from my son that he was carrying, which he thought was a bad thing that he had done. That one thing was when he was younger, he used to sneak and read my college books. My son is unique in his own way. He loves wisdom. He'd sit and listen to my dad, his granddad, and any other older individual that had a story to tell. I know you've all heard the phrase, 2 wrongs don't make a right. Well, when my children were young and fought each other, everyone got in trouble and suffered the consequences. My son was not everyone's buddy here at the courthouse or in a legal family, but he has lots of people that love him, whether it's family or friends. There's always that person you can count on for anything. He has been a one-man show, helping people move, babysitting, a father to his children, mentor, good listener, provider, and the list goes on and on. 2 of his older children are older, that doesn't make sense. 2 of his children, the older children, he was in the process of teaching them about their heritage. When Theodore was young, I'd have him and his siblings read an autobiography once a month and tell me about it. We have photos of him marching with the Bucks at the rally for George Floyd before all of this. He had his oldest child with him, teaching and explaining to her how some people can be so cruel and evil, that all lives matter. Also, talking to her about her rights so she would understand and not be lost in society. I wish his 2 oldest could be here so you can listen to how intelligent they are, to listen to what he has instilled in them. if you're going to sentence my son, I ask that you take leniency on him because he doesn't deserve what has happened to him that led to an unfortunate death. Thank you.
Thank you.
Last, Your Honor, we have Rose Scott.
Fine. Ma'am, if you can state your name, spell your first and last name, please.
Rose Scott, R-O-S-E-S-C-O-T-T.
Go ahead.
Dear Judge, I met Theo in November 2021, and my greeting to him was, "Hello, grandson." My age wisdom immediately informed me that this young man needed support, love, to become a contributing member of society. Yes, I have supported him since that time to try and obtain his freedom. I attended court, rallies, and yesterday witnessed his marriage to Ruby Mizell. That was Tuesday. Your Honor, clearly the tragedy of Mr. Cleereman's death could have been avoided. However, blame should be shared with all three individuals. I agree with the Cleereman family. The loss of a loved one leaves a forever void. I am grieving with Theo's young family at the possibility of losing their dad to years of incarceration when they need him the most. Theo is only 32 years old with great potential to make meaningful contributions to society. Please release Theodore Edgecomb. I'll give him the least, smallest sentence ever. And I want to speak to his saying that I didn't mean to do it. I'm a Black woman who grew up in Georgia in the 40s and the 50s. And we were groomed and taught, don't go there because you'll get into trouble you'll never get out of. And when I heard that statement here, I thought, he didn't mean to do it. He didn't want to kill anybody because he's not that type at all. But faced with that, he said, one bullet. I didn't mean to do it. And you have to understand the scenario of his fear. His fear is the same fear that you see with most Black men. It was worse when I was a child growing up. There was a deadly, embarrassing fear that I saw from Black men that truly embarrassed me. Why are you doing that? Why are you doing that? Why are you afraid of? But we have a reason to be. So when you hear him say it was self-defense, it was self-defense for him. Thank you.
Thank you.
Your Honor, as for my remarks, as opposing counsel noted, this case involved an escalating dispute between two citizens one summer evening in September 2020 on Brady Street here in downtown Milwaukee. Now, the case, it is certainly a tragedy, and the public took a great interest in this case with vastly differing opinions. Today, the court is presented with a very difficult task in fashioning the appropriate sentence in a hotly contested case. Now, Mr. Edgecomb, he was found guilty by a jury of his peers, and that verdict has to be respected today. This is a case that requires a prison sentence, no doubt. But I feel, Judge, that this case This case is quite different from the vast majority of cases that come before the court. It is not a case that involves a gang-related shooting or a drug-related transaction. It's not a drive-by shooting where a house or a vehicle was riddled with bullets, with a cold-blooded intent to kill a target, and at the same time recklessly endangering the safety of others. It did not involve a domestic violence escalation that resulted in someone's death. It was not a case between two parties that had a violent history together, nor did it involve any sort of premeditation or intent, or accompany any sort of crime as in a felony murder case like an armed robbery. The point is, Judge, this case was completely random, it was unforeseeable, and it suddenly turned the lives upside down for two men and the loved ones of both parties involved. These men were total strangers to each other and were otherwise going about their normal daily lives on a Tuesday night in downtown Milwaukee, just trying to enjoy one of the last days of summer. This case is about as random as a case can be. And ever since the pandemic began about 2 years ago, Milwaukee has been experiencing an alarming increase in violent crimes, shootings, and homicides. And I can only speculate, Judge, as to what has caused this staggering increase. Counsels noted that guns are clearly not the answer. This case did involve a gun. It also involved a vehicle, which Milwaukee has seen lots of crimes involving that as well. What we do know about this case is that it happened pre-vaccine in September of 2020. And back then, Your Honor, I do remember people were on edge. It was tense, it was scary to be out in public, and at that time, the future was uncertain. We all had heard stories that summer of people snapping out in public, whether it was in the streets, department stores, or during protests. I think it's fair to say people's mental health during that time was poor, and I believe this especially was the case back in September of 2020, particularly in this state, because just 3 weeks ago, we had the situation of the Kenosha riots just south of here, 30 or 45 minutes. So looking at the overall context of this case, I think the court can consider this case is unique in that it just involved two ordinary citizens who were complete strangers and did not otherwise involve any sort of criminal activity. The short fuse that people were exhibiting during the pandemic, after being isolated, after being pent up, quarantined, I feel that that was likely at play here, and it resulted in both parties suspending their judgment and escalating an otherwise avoidable situation. The loss of life here is a tragedy, no doubt. It's also heartbreaking that Mr. Edgecomb, with a very limited prior record, a misdemeanor conviction, coming from an otherwise stable, normal upbringing, hardworking mother, father with a law enforcement background, as noted in the PSI, a man who stayed out of trouble for 30 years of his life, now is facing a sentence for a very significant amount of time behind bars. Now, the state did discuss some of the facts in the case, and I'm not interested in litigating a self-defense, the merits of that today, but I did want to talk about some of the mitigating circumstances. Now, first, regarding how the parties that night crossed paths. The Cleeremans were coming from Scaffidi's after a night at the bar. Mr. Edgecomb was picking up food at Dynamite on Brady Street to have dinner with his daughter. And as we heard from one of the speakers today, the daughter now blames herself for what happened that night. Eventually, they crossed paths. Counsel indicated that he did not believe Mr. Edgecomb's version of events. We know for sure, Judge, is that Mr. Edgecomb was almost hit or was clipped or grazed. I think the Cleereman's testimony indicated that she had to swerve to avoid hitting him. And Mr. Edgecomb testified that he was knocked over. As far as there was a lot of time that was spent during the trial on the investigation the police did in trying to obtain any video surveillance footage of that. And while that's not the most important thing in the case, certainly the least relevant of the three possible videos in the case showing the three different encounters, if we had that, we would have understood what exactly occurred. And it would have been important to take that into account in terms of Mr. Edgecomb's fear that night and what had prompted that in the overall context of course, a series of events that occurred all within a few minutes. The police did do some investigation, but it appears that it didn't extend all the way to the paths that the Cleeremans had coming down Brady. The second encounter, we saw that. The court clearly has seen that video many times. What we see is a punch Mr. Edgecomb threw at Mr. Cleereman suddenly, and it seemed to be a very strong punch, which begs the question, why would a man just go up to another man and punch him in the window if it was a minor incident? It's really hard to say, but it clearly enraged Mr. Cleereman so much that he wanted to confront Mr. Edgecomb at the time. Completely understandable. I think anybody in Mr. Cleereman's position would have wanted to do that. Mr. Edgecomb fled, however, on his bicycle, as we saw, and that's why this case became tricky. Now, putting that all into context, certainly Mr. Edgecomb was clearly wrong in throwing that punch, and during his testimony, he accepted that. He was also wrong for having a firearm that day, and he entered his plea in this case before the trial, accepting responsibility for that. He disobeyed a court's order, and there is no justification for that. What transpires then is we see the vehicle pursue Mr. Edgecomb. Now, with all due respect to Mr. Cleereman and his family, I'm not interested in tainting the memory of a loved one. And I think we can all respect Mr. Cleereman was an attorney, opposing counsel, like counsel seated here, like the court. But Mr. Cleereman also was an officer of the court. He was a man of law. He was an attorney. I think we all can agree that it would have been more prudent that night to have either gone home or have called the police, not take matters into your own hands. There's a lot of things we can look at into what all the parties could have done. Clearly, Mr. Edgecomb could have done many things differently. The Cleeremans also could have decided not to pursue Mr. Edgecomb. They did pursue him. If they wanted to speak to him, they certainly, that's also very understandable. Getting out of the car, placing yourself at risk too. Now, my point is, these are some mitigating circumstances I think the court can consider. And we see Mr. Cleereman attempt to intercept Mr. Edgecomb, and then at the stairwell, there's a confrontation. How we want to characterize whether it was an approach, jogging, running, charging, there was all kinds of descriptions of that scene where we see Mr. Cleereman closing the gap. And then, as counsel noted, there's one bullet that goes off, and to Mr. Edgecomb's credit, it was only one shot. On the other hand, counsel's correct that it was a shot to the head. And that conduct, the jury found to be reckless with utter disregard. And that's the crime that Mr. Edgecomb is being sentenced on today. So it wasn't an intentional act, as per the jury's verdict, but something that was so reckless. Now, in the sentencing memo, Your Honor, that I submitted to the court, there is some discussion about utter disregard. And what I thought was important that the court can consider in terms of mitigation is that utter disregard requires conduct that just has no justification or excuse. And the Court of Appeals and the case law has said that actions taken in self-defense, while not antithetical to utter disregard, are inconsistent with utter disregard. I think that's something that the court can consider in terms of mitigating circumstance. The Court of Appeals has also instructed courts to look at, and for juries to look at, the type of act, the nature, why the perpetrator acted as he and she did. And I don't see any other motive for Mr. Edgecomb acting the way he did if he was the one that was being approached or ran at or charged at. And I think it's clear that Mr. Cleereman's intent wasn't only to talk to him, but perhaps to have some sort of response to the punch that he had suffered, unfortunately. So I think that is mitigating, Your Honor. And as far as the jury's verdict, that has to be respected. But this case does not require a specific minimum amount in terms of incarceration time. In addition to that, the law requires the court to consider the minimum amount of incarceration to meet the primary sentencing objectives. Now, Mr. Edgecomb had testified at trial, and his testimony was confusing to many viewers and counsel alike. In my conversations with Mr. Edgecomb, he did want to clarify some of his statements, and he wanted the court and the public to know certain things about what transpired. Mr. Edgecomb would like everyone to know the following. I never intended to kill Mr. Cleereman, but I realized that I have killed another human being, and that weighs heavily on me to this day, and will continue to for the rest of my life. Although I was angered by Mr. Cleereman for what he said when his vehicle struck me, I should have not have punched him, and I wish I had never taken that action. I never expected the situation to escalate as quickly as it did. When I described the gun just going off at trial, I meant to say that I did not even remember pulling the trigger. Everything happened so fast, and I was startled once Mr. Cleereman was only a foot away from me. I reacted in the heat of the moment, and I do not believe I could have reacted in a different way, honestly, under these scary circumstances. It was an involuntary type of reaction without any deliberate or premeditated intent on my part. I was in shock and disbelief once I realized what had happened. I do understand I was not able to legally possess a firearm at the time, but I still feel that had I not had the firearm that evening, I may have either been seriously injured or killed that night. I believe my actions were in self-defense, but I understand that a jury determined that my actions were reckless in nature. So with that being said, I ask that the Cleereman family find it in their hearts one day to forgive me. I also would like to express my apologies to my family for the mistakes that I have made. To your honor and the court, I would ask that you have some mercy upon me, and may peace and blessings of God be with everyone affected. Thank you. In summary, Your Honor, this shooting was not an intentional homicide in the first or second degree. It was not a shooting that was with an act of hate or malice. It was one bullet, not with an intent to kill, but with an unreasonable defensive measure. It was a reaction, but was unjustified as determined by the jury. As far as a sentence, I'm asking the court to impose a sentence of 12 years of initial confinement, followed by 13 years of extended supervision, which I'm joining in with the state on that portion, for a total of 25 years. I'll leave it up to the court to determine how to divide that sentence among the bail jumping charges. While the bail jumping charges are aggravating circumstances, I think the court can take into account that Mr. Edgecomb accepted responsibility for that well before the trial in this case, and recognizes the error in his ways in possessing the firearm. Had that not been the case, this may have been avoided altogether. Thank you.
Thank you. Does your client want to make a statement, or was that what you read?
No, Your Honor. The reason he also doesn't want to make a statement is after seeing him in the jail yesterday as well as this morning, he did have a tooth surgery and a removal. It's difficult for him to speak, and he did show me he does actually have some bleeding as well. So that is the reason that he's choosing not to make a statement today. But that was his statement, which I did read for the court.
Fine. In fashioning a fair and appropriate sentence, as I'm required, I'm looking at the gravity of this offense, the defendant's character, the need to protect the public, along with things like punishment, deterrence, rehabilitation. And all of those things are factors in this case, and factors for my sentencing. First of all, I want to say that, and I've told the lawyers this previously, and I think I put it on the record previously, but though he was an attorney, I did not know Mr. Cleereman. He did not practice in front of me. By all accounts, the letters, the victim's wife, everything that's been presented certainly appears that Mr. Cleereman was an upstanding citizen, but I did not know him. You know, the state referenced this, and I'm going to pick up one of the state's comments. This trial had a lot of noise around it, outside noise, antics from people not involved in this case. But this case was about the actions of the defendant. It was about the actions that occurred between two men in September of 2020. And I think it's incumbent upon me to say that a justice system that is constantly berated in certain segments of society is sometimes berated unfairly. This is a case where the justice system worked. The defense will recall, and the state will recall, there were actually two juries impaneled in this case. The first jury I dumped for various reasons that don't need to be discussed. The jury that eventually heard this case was the most diverse jury that I've ever seated in Milwaukee County. 6 people of color, 6 whites, including 5 African Americans. That jury, who truly was a jury of the defendant's peers, found the defendant guilty in about 2 hours. The jury decided this was not self-defense. This was a homicide. The defendant is being sentenced for a homicide. There's a lot to discuss related to this case and related to the defendant and the defendant's character, the defendant's actions, the need to protect the public, punishment, and other factors. But first of all, again, as the state mentioned, this case is part of the insanity that goes on in Milwaukee County with guns. And just so we're clear, Mr. Edgecomb is being sentenced only for his actions, not the actions of any other person or any other case. But as the state pointed out, and the state has heard me say this more than once on the record, homicides in Milwaukee County are out of control. In 2019, there were about 90. Then we almost doubled that in 2020. Then we increased it again in 2021. And though it's only early April, we're on pace to potentially double that homicide rate now to 400. And most of it is idiocy over arguments when people pull out guns. The state used this in their closing argument, and it's correct. Mr. Edgecomb brought a gun to a fist fight. Certainly, I saw the video, as the state said, 10 times, 20 times. I can't remember how many times. There was some, depending on how you believe, or which side you believe, there was some, not exactly a confrontation, but either the Cleereman's vehicle swerved, or Mr. Edgecomb cut in front of them, or there may have been some contact between the car and the bicycle that Mr. Edgecomb was on. That was not caught on video. Then there was the confrontation where Mr. Edgecomb bikes west on Brady Street at a very fast clip. The Cleeremans are waiting in traffic. It's a short confrontation, but Mr. Edgecomb slugs Mr. Cleereman through the car door window, hits him pretty much, certainly in a violent fashion. Then Mr. Edgecomb peels off, turns right, and heads up the bridge on Holton Street. I'm sure that Mr. Cleereman was frustrated and upset that he'd just been punched by Mr. Edgecomb. And I'm sure that the victim's wife probably, I'm sure, questions why she turned and followed Mr. Edgecomb, even if that was what Mr. Cleereman asked her to do. But to respond to the defense inference, I'm not going to be in a position here where I'm blaming the victim, or I'm blaming the person who was shot to death. Because that's along the lines of, well, don't drive on Capitol Drive because it's a war zone, because people drive so badly on that street that it's not safe. Don't go into a certain neighborhood because you might get shot. Don't approach someone, I would say he was striding quickly at Mr. Edgecomb, because he might have a gun. In a community that did not feel obligated or for some reason compelled to resolve arguments and fistfights with a gun, those kind of dangers would not be present, and this situation would have been resolved differently. Looking at the defendant's character, yes, I read there were probably at least a dozen letters on behalf of the victim, probably a dozen letters or more on behalf of the defendant. I read those letters. I read the pre-sentence investigation. I read the sentencing memorandum, which was only a few pages, that was submitted by defense counsel within the last day or two. certainly, as the state conceded, Mr. Edgecomb is nowhere near the worst of the worst. I see defendants with far longer records, with much worse behavior, with far more dangerous behavior. This case did not involve, for instance, Mr. Edgecomb, as the defense pointed out, being in a gang or as part of an armed robbery or as part of some other form of violence. But as the state pointed out, well, Mr. Edgecomb's record is relatively limited, fairly limited. It has in the past involved allegations of and at least one conviction of carrying a concealed weapon. And Mr. Edgecomb, you were not to be possessing a weapon when this occurred. Had you followed the judge or commissioner's order to not have a weapon on you, this resolves as a fist fight. And Mr. Edgecomb, there's only so much credibility I can give to your statements, and the jury rejected it completely, but to your statements that you feared for your life. This, even if you attribute the worst motives to Mr. Cleereman, and I'm not, but for the sake of the argument, the worst case scenario here should be a fist fight. You're 20 years younger than the victim. As the state pointed out, Mr. Cleereman did not have a gun. He had a small switchblade that was in his pocket that he never brought out, that he never brandished, based on all the evidence and all accounts. And the defense said, well, this was sort of a random situation, which, depending on how you look at it, that could be mitigating or it could be an aggravating circumstance. Had the Cleeremans stayed where they were for another 10 or 15 minutes at the restaurant or bar, had Mr. Edgecomb decided to go to a different restaurant that was not on Brady Street, this confrontation almost certainly never occurs, and Mr. Edgecomb would be going on with his life, but so would Mr. Cleereman. And Mr. Edgecomb, no matter how difficult this is for you and your family, no matter what the sentence is, you killed another person. And your testimony, which the jury clearly rejected, and the jury made their decision that this was not self-defense, was not particularly credible. To say that, and you said it repeatedly on the stand, the gun just went off, when what the testimony was from multiple eyewitnesses was that you pulled up your hand and went like this, right at the forehead of the victim, and shot the victim almost directly between the eyes. That's not an accident. That's not a gun just going off. That's you brandishing a weapon and pointing it at someone's temple. Obviously, the defendant has a right to a trial. He exercised his right to a trial. The jury made a decision. But Mr. Edgecomb, you engaged in incredibly bad decision-making. You did not need to pull out a gun, and you certainly did not need to pull the trigger. While there was discrepancies in the testimony, there were, as I recall, 4 witnesses, not including the victim's wife. The 4 witnesses, one person was driving by, one person was behind the Cleereman's vehicle. There were the 2 gentlemen sort of across the street or on the other corner. And everyone basically agreed there were some discrepancies, that the car pulls over, that Mr. Cleereman gets out of the car, he starts, I would say, striding towards you, and you immediately pull out a gun, point it right at the victim, and the victim goes straight down dead. The whole thing happens in a matter of 2 or 3 seconds. I'm not sure, Mr. Edgecomb, that you understand the depths and the gravity of your offense. Mrs. Cleereman's life and the life of her children will never be the same. There will never be a day that goes by that they don't think about this situation. I'm sure that, as Ms. Cleereman said, it's bad enough to find out that a relative died, or a relative had a heart attack, or to be told to have a police officer come to your door and say that a friend or relative, or God forbid, a spouse was killed. But to watch your spouse be killed right in front of you when you're 10 or 20 feet away, I can't think of anything worse. And while, as the state pointed out, Mr. Edgecomb, your record's not the worst. You know, you're employed for the most part. You have an education. You were, it appears, supporting your children. You did a number of things in this case that aggravated the circumstances, aggravated the case both literally and figuratively. You claimed basically that this was self-defense. Yet, rather than staying on the scene or turning yourself in, you go on the run for 6 or 7 months. You leave the state. You allegedly ditched the gun somewhere in Indiana. You get picked up 6 or 7 months later in Kentucky. There's never been any acceptance of responsibility for your actions, Mr. Edgecomb. None. It struck me as I read the letters from both sides, and again, there were numerous letters on behalf of the victim describing Mr. Cleereman and numerous letters on behalf of Mr. Edgecomb, that the two people involved in this tragedy have family members and friends that think very similar things about them. As I said, Mr. Cleereman was clearly, based on the letters and his career, a fine, upstanding citizen. The letters all indicate that he was a good father, a good parent, a good spouse, a law-abiding citizen. The letters that were written on your behalf, Mr. Edgecomb, also are similar. Most of them say that you're a good father, that you've provided for your children, that you've got an education. And yet, because of a terrible, terrible, callous, thoughtless decision, we have someone who's killed in his mid-50s. And the state's correct. This is another case of people having no impulse control. I have other pending cases in front of me where, for example, in a bar, one guy bumps into a guy's brother. The brother pulls out his gun, starts firing up shooting up the entire restaurant, the entire bar. One person's killed, another one's injured. I had a case that went to trial where defendant's mad because somebody else allegedly pushes his ex-girlfriend. He decides to drive by the house and shoot and kill him. People have no impulse control in this community. And Mr. Edgecomb, had you not been violating the law and the order to not have a gun, then worst case scenario, this goes down as a fist fight. Broken nose, broken eye, someone's glasses get knocked off. The state discussed the defendant's not just record, but his multiple contacts with the criminal justice system. I'm giving that limited weight because it is a limited record because it's outweighed for the most part by other characteristics from the defendant in terms of his prior record or lack thereof. The pre-sentence investigation basically says, I'm paraphrasing, that the defendant's sort of a moderate risk to the community, a moderate risk to reoffend. Certainly the defendant does need to be punished. He needs to be sentenced. You know, this is obviously a criminal, strike that, obviously a prison case. There needs to be deterrence, both specific deterrence to Mr. Edgecomb and general deterrence to the community. That it's time for people to stop resolving arguments or confrontations or any possible disruption in their life with a gun. Not just brandishing it, but firing it. And Mr. Edgecomb, again, all four witnesses that were independent to this case and the victim's wife all said that you pretty much immediately, as Mr. Cleereman came at you, pulled the gun up, pointed it at him, and killed him. You shot him right here, almost right between the eyes. That is not an accident, as you testified. It's not. That's not the gun just going off. That's completely incredible, completely unbelievable. And I'm sure that's what the jury was thinking. I certainly understand the victim's family and their request for the maximum sentence on the first-degree reckless homicide, which the defendant was found guilty of. As the state said, and as I'm sure they've explained to the victim's family, this is not a maximum case. Maximum cases are, as the state noted, reserved for, frankly, the worst of the worst. It'd be someone who has a far longer record than Mr. Edgecomb, committed a homicide in a worse fashion, all sorts of other aggravating factors that aren't present here. But again, the jury of the defendant's peers determined that this was not self-defense. They did not deliberate for a long period of time, 2 hours, 2.5 max. I mean, Mr. Edgecomb, one of your family members mentioned explaining to your children why you're not coming back or why you weren't bailed out. That's nothing compared to having young adults or older children never see their father again, to have a father never be there for a wedding or graduation from college or purchase of a first home. Any explanation that has to be given to your kids is nothing by comparison. A, because you're still here, and B, because you engaged in this behavior. Part of this sentence, frankly, is punishment. A lot of it is punishment and deterrence. You know, a civil society can't allow people to brandish weapons and shoot other people in the head. One would think that goes without saying, but with the crime in this community, that message has not gotten through to large segments of Milwaukee and Milwaukee County. Every sentence that occurs in a homicide, let alone any other case, also needs to be proportionate to what other similar cases and other similar situations receive. Every case is unique, obviously. Every set of circumstances is different from one case to another, including from one homicide to another. I'm certainly aware of all the requirements of Galleon and similar case law regarding what's necessary in terms of punishment, regarding what's necessary in terms of confinement. And candidly, the request from the defense is not appropriate. The request from the state is candidly lower than I expected it to be. And for anyone that doubts that, within the last 10 days, I had a case that was very, very similar, where a defendant alleged self-defense. The jury did not believe it. That defendant testified, did not testify truthfully. And in that case, the state asked for over 30 years. So the state's recommendation in this case is on the low end of what would be recommended in a homicide similar to this. That's just reality. The one thing the state did not discuss is obviously there was the aspect of provocation in this case. Mr. Edgecomb, I don't know what was going through your head. Whatever happened initially, and I don't believe the testimony or the implication that you were hit by the Cleereman's car and you rolled up on their side of the car or the front of the car, that's not plausible because your bike was not damaged, you weren't injured, there was no visible damage to the car. That's not plausible. But whatever did occur, for you to be so hot under the collar that rather than ignore it or drive by and handle it in some other fashion, you slug through a window and do significant damage to the victim, punching him in the face and in the eye and knocking his glasses off, causing abrasions and cuts. I can't imagine what was going through your head and why you thought that was an appropriate way to respond to whatever happened initially that was not caught on camera. And then again, ultimately, Mr. Edgecomb, there was no need whatsoever, even if, and yes, Mr. Cleereman was striding towards you, for you to pull a gun and within a matter of a couple of seconds, put a bullet in his skull. I apologize that that's a very candid description of what occurred, but that's what occurred. Having said that, I'm sentencing the defendant as follows, largely following the state's recommendation: 25 years of initial confinement, 12 years of extended supervision. That's on count 1. That is the absolute minimum required to punish the defendant, to incarcerate him, to send a deterrent message to this community. 25 years of initial confinement, 12 years of extended supervision. This was a homicide. That sentence is consecutive to the end of the case, consecutive to any other sentence. And count 2, which is the bail jumping, I'm sentencing the defendant to a total of 4 years, 2 years of initial confinement, 2 years of extended supervision. That sentence is concurrent to count 1, concurrent to count 3, and concurrent to any other sentence. And count 3, which is the misdemeanor bail jumping, I'm sentencing the defendant to 6 months in the House of Corrections or in jail. That sentence is concurrent to count 2 and concurrent to count 1. It's the court's specific intent that the defendant serves 25 years of initial confinement, 12 years of extended supervision. In this case, the defendant is not eligible for the challenge incarceration program, not eligible for the substance abuse program. The defendant will be provided a written explanation of the determinant sentence. While in the institution, I'm authorizing up to the maximum amount be taken out of the defendant's in-custody earnings, wages, funds, or monies of any sort. I'm granting the state's request for restitution, which was stipulated to. The restitution amount is $4,840. The restitution is to be paid to the victim's wife. Conditions of extended supervision are as follows. First of all, because this matter is a felony, Mr. Edgecomb is not allowed to own or possess a firearm, a gun, at any time ever for the rest of his life. He's not allowed to vote in any elections until civil rights are restored. They will be restored at some time in the future, but until then, you're not allowed to vote. Mr. Edgecomb, you will have the right to appeal. An appeal would have to be filed within 20 days. Conditions of extended supervision are as follows. First of all, no further law violations rising to the level of probable cause. Mr. Edgecomb is not allowed to own or possess a gun or a weapon of any kind. Mr. Edgecomb, when you're released, you are obligated to work full-time. You're to pay restitution if it's not already been paid while you're in the institution. I'm ordering the defendant to pay all costs, fees, and surcharges, both mandatory and non-mandatory costs, fees, and surcharges. They're to be paid first while in the institution, then if not paid while in the institution, paid while on extended supervision. While on extended supervision or while in the institution, I want the defendant to have an AODA assessment for any drug or alcohol needs. If there are any AODA needs, he's to be treated in the institution or while on extended supervision. While on extended supervision, Mr. Edgecomb is not allowed, strike that, I'm ordering absolute sobriety. Mr. Edgecomb is not allowed to drink alcohol. He's not allowed to use any illegal drugs. Beyond those conditions, I'm going to leave the further conditions of extended supervision up to the Department of Corrections. Again, in this case, because of the nature of this offense, the defendant is not eligible for the challenge incarceration program and not eligible for the substance abuse program. I will provide the defendant with a written explanation of the sentence in this case. Again, the defendant has the right to appeal. An appeal would have to be filed within 20 days. Last is state. Am I forgetting anything? Did I leave anything out?
No.
Defense?
No, Your Honor.
All right, then we're adjourned. We're off the record. Thank you.